Chair now recognizes the gentlelady for the purposes of offering and explaining her amendment.
Mr. Chairman, I thank you. I am taking up this amendment but intend to withdraw it, but wanted to spend a few minutes reviewing the issue. I want to thank Mr. Chairman and the members of this committee who have worked on this issue historically. I think there has been some progress made, but I think it's important for us to look at rape in the military as a serious stain on the military and on our ability to oversee it. The last SAPRO report was disturbing, to say the least. The charges have actually decreased, the court-martials have fallen, and the convictions have plummeted. In terms of the commander-initiated actions, they dropped by 23%. The number of initiated court-martials fell by 8%, and the number of perpetrator convicted of committing a sexual assault decreased by 22%. In short, fewer commanders decided to bring charges, and of those charges, many fewer were successfully prosecuted. Some, including Secretary Panetta, think that the answer is to move disposing authority up the chain of command to the 06 level. Secretary Panetta and my colleagues, I hope, are correct that this will solve the problem, but I'm not as optimistic. Some of the forces already adhere to this practice of giving disposing authority to 06s, and yet commander actions, court-martials, and convictions also decreased in those services as well. While many commanders are making the right decisions, I fear many are not. This may not be done with malice. The fact patterns of some of these cases run counter to what the commanders think they know. How could a model soldier, a water walker with a perfect record, commit such a heinous act? This runs contrary to what commanders believe and what they depend on in executing their missions. Ask experts in and out of the military, and they will tell you that these are the most difficult and complex cases that come across their desks. And while there's no question that training has improved, institutionalizing that training and subverting ingrained bias, I fear will take years. That is why today I'm offering the core of H.R. 3435, the STOP Act, which I introduced this Congress. There are more than 122 co-sponsors on this bill. My amendment takes sexual assaults out of the hands of commanders and places the jurisdiction in the hands of an impartial office, but I underscore this, within the military, staffed with experts both military and civilian. This office would oversee the investigation and, if appropriate, the prosecution of these cases. This office may consult with commanders and even refer these cases back to them if they deem appropriate. Some argue that taking discretion from commanders undermines the motivation to maintain a command climate that minimizes the chances of sexual assault occurring. I think the exact opposite is the case. With greater accountability and transparency of offenses, the greater the incentive commanders will have to make sure they don't happen on their watch. We have 19,000 cases that are actually being accounted for each year. Only 13% are being reported. This issue isn't going away. I hope the steps that have been taken both by the committee and previous NDAAs and by the Secretary of Defense will move us in the right direction. But I do think that we've got to be vigilant in addressing this issue. I ask unanimous consent that this amendment be withdrawn.
Gentlelady.